नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
Otherwise, in terms of Article 239AA Clause 4, he is bound 3A, he is bound by the aid and advice of the Delhi Council of Ministers. And in those areas where he disagrees with that opinion, he refers it to the President, where obviously technically he is bound by the aid and advice of the central government. I've spoken a lot. I hope you have followed the three clear classifications. Why I'm saying studying it one after the other helps, because the principle of aid and advice is owing its origin to parliamentary democracy. It's owing its origin to what both the judgments talk of constitutional morality. Constitutional morality is something that, a phrase actually that Dr. Ambedkar used in the Constituent Assembly. And he said that constitutional morality doesn't exist in a big way in India, but we must develop it. And he was talking about respect for people. He said India is a deeply divided society. Okay. In fact, Dr. Ambedkar, in his Annihilation of Caste, if you've read his long essay, Annihilation of Caste, he uses an expression there called graded inequality. That India is so hierarchical, unlike the European society which had bourgeoisie and proletariat and just two classes. India, because of its caste system, has variety. Each varna thinks it's superior to the other. And he called that graded inequality. And therefore, in that context, in the Constituent Assembly debates, he used the phrase constitutional morality to say that we must try and develop this idea amongst Indian people that people all are worthy of dignity and should be treated equally. And in this 5-judge bench decision, which is the Union Territories case, there is big discussion on constitutional morality. And both Justice Deepak Mishra as well as Dr. Chandrachud, Justice Dr. Chandrachud, tell us that this principle of constitutional morality is embedded in the principle of parliamentary democracy. And the collective responsibility requires aid and advice to be given. So basically that principle of aid and advice, they are identifying it as a principle of constitutional morality, as a principle of parliamentary democracy, and therefore, very importantly, as a basic feature of the Constitution. And therefore they say we cannot accept an interpretation that reduces the aid and advice of the Delhi government to a zero. Can't, because it is a constitutional feature. And then they say that the nature of that advice is also from another point. They say India is a federal country. And looking at it pragmatically, and that's the phrase that Justice Deepak Mishra uses, pragmatic federalism, okay? We looked at amphibian federalism, Justice Beg. There's another new phrase for you, pragmatic federalism. And he says, keeping pragmatic federalism in mind, we must give some role to the Delhi government where it gives its aid and advice. So is the aid and advice binding, Chitra? That's your question. For the president and for the governor, by and large, it's binding. Except once they can say nahi, but then second time around. But in the Union Territories case, it is not binding because of the proviso. But if the LG decides not to be bound by the aid and advice, and that's the importance of the judgment, he cannot do it whimsically. He cannot do it just because mereko acha nahi lagte, Chief Minister. No. There must be a difference, and that difference must try to sort it out. You must make an attempt to understand why. So this exception cannot be done in a mechanical manner and therefore everything. You must try to exercise it. And as I was talking about judicial review, by the 5-judge bench making it a condition precedent, though I have no authority to say it, but I'm just reading it as the consequence of the judgment. If tomorrow the LG were to say refer it to the president, If somebody challenges the use of the proviso and the reference to the president, you could ask on what basis was the difference of opinion? How was it sorted out? Show me the record that this condition precedent was fulfilled. And you can do that because the judicial review of that decision, the materials are available to you following the SR format. You can look at it. So you can say, when the Chief Minister said X and you decided Y, did you take steps to solve the difference? And you can, as a litigator, ask for the record to be produced. Show me. Number two, why did you arrive at a Y decision when the cabinet said X? What is the material on which you arrived at your Y decision? We are not substituting our opinion for that of the LG, but we are merely asking, show me the material on the basis of which you came to a contrary decision to that of the Delhi Council of Ministers. And number two, show us the steps whereby you tried to resolve the X opinion of theirs and the Y opinion. How many times did you meet? Show us the record of meetings, blah, blah, blah. If these things are not available, I think it would vitiate that reference. That's what the judge decision is saying. We have, after that 2018 judgment, had the 2019 judgment where the question was who has the right to appoint public prosecutors, special public prosecutors. And the five-judge bench, the 2018 five-judge bench had said that all materials and decisions of the Delhi cabinet must be periodically told to the LG so that he can decide whether he wants to take a contrary opinion or not. Now, where the decision is conveyed in all matters of entries other than 1, 2 and 18, you are bound by it. But the difficulty is the proviso. LG can disagree even with the decision taken in other matters. But what the judgment of 2019 is now telling us is, once you have conveyed the decision, the minister can immediately act. You don't need to wait for LG's concurrence. You only have to inform. However, the LG in turn can refer the matter to the president, and if he gets contrary decision, then he can revoke the decision subsequent to the receipt of the fresh aid and advice from the central government. So the position of the LG is at once a nominee of the President of India, but because of 239AA, it's also for a little bit of why I say pragmatic federalism, or rather why Justice Deepak Mishra says, I don't say, is because despite all 239AA, still Delhi is not a state. It is still a union territory. Therefore, normally in federalism, you don't have unlimited right to make laws. Many areas are still bound by the LG, and even where you take decisions, the proviso gives a sort of veto power to the LG. It's not a veto power because it's not a correct word to use. I say sort of because he can negate that decision of the cabinet directly. Okay. And therefore, special prosecutors, let me come to the decision of the 2019 case. Special prosecutors are not appointed by the Chief Minister, but by the LG. That's the decision there. Okay. Now, we've spent a lot of time. I've spent 3 classes because I felt it was an important point. Now, let me come to the last part of this unit, which is the pardoning power under section article 172 and...
Ma'am, I have a question.
Yeah, please ask.
Ma'am, can 239AA fourth proviso be said a discretionary power of the LG while mentioning his power of that proviso?
Just explain what disciplinary power?
No. Discretionary power of LG, that proviso can be said.
No, we shouldn't say discretionary power. No. Because discretionary power means that he is taking a decision on his own. And this discretion has been greatly, the decision to go under the proviso has been circumscribed so much now by the 5-judge bench decision. So loosely speaking, yes. But why I said not discretionary, just one moment, please. Sorry, my call got disconnected. Loosely speaking, it is discretionary, but it's not a correct word to use. You will notice it's not been used in any of the judgments. The reason being that discretionary means that it is a proper area where you can exercise your discretion. I'm sorry, I had a problem. Okay, I'm extremely sorry. My thing got disconnected. I've forgotten what I was saying. I was talking about the discretion. That's right. So the word discretion is not therefore being used, okay? Because discretion means that he has an area where he can act independently. And the judgment tells us either you're bound by the aid and advice or you're bound by the president. But the decision making, is the decision making within his discretion, if you are asking me that, then yes, but even then it is not as if that there is a complete discretion to decide. It is bound by there being material for you to come to a contrary decision, and before you refer it to the president, you must try and resolve the difference. So we don't normally use that word discretion to describe the function that the LG performs under the proviso. Fine. Now let me go ahead with pardon. Is there any other question anybody had? Okay, now let's come to the last part of one of our executive functions, which is the pardoning power. I'm going to take up president first, and then we'll come on to governor. Under our doctrine of separation of powers, I just want to ask a general question. Anybody can try and answer it immediately. Once the Supreme Court has decided a decision, okay, it says supreme but not infallible. Okay. Supreme but not infallible. So my question is that once the Supreme Court has said, for example, you take Nanavati's case. We studied it in first year. You may have seen that film Rustam, no? You saw that film Rustam? I hope you all saw that film Rustam. Yeah. Now, why do you think we have this mercy power? What is the purpose? What is the purpose of this mercy power? Is it a good thing or does it violate separation of powers? I am asking you a question now. Why do we have this mercy power or the pardoning power? And is it a violation of doctrine of separation of powers? Two questions. Anybody put on the mic and answer. I want to hear. Yes.
Ma'am. Ma'am, it's not a violation of a separation of power. It is a power intentionally given to the executive. Its objective is to see in a larger public benefit if any error or it's like a safety valve. If anything goes bad with the judiciary, so there exists a last chance where executive can correct it.
Okay, but let me put a counter question to you. Once a matter, for example, let's take death sentence. Death sentence is such a final punishment. It can never be decided only at one judicial level. For a minimum, death sentence would have first come to the district court, district judge, then it would have come to high court, then it would have come to Supreme Court. Right? Even in the army, where capital punishment is under court-martial can happen, it will be done by the court-martial where the judge advocate general would have been the prosecutor, all that would have happened. Then it would have come to commanding officer and it would have been confirmed by the highest appellate authority, and then only it will be carried out. So death, for example, never is done at first level itself. Then in which case, by the existence of that pardoning power, are you not diluting the legitimacy and the credibility of the judiciary?
No, ma'am. Judicial procedure itself is a complete story. This mercy clause, it's not something to alter that or question that. It is just they are trying to reduce the effect of that judicial pronouncement. And main objective is because even that criminal system have final objective is for public welfare. So if by this mercy petition, which president or governor can see, president can see in the sentence. So if larger public welfare is fulfilled by this action, then still it justifies that.
I have another
intention
question for you. Either you can answer it or somebody else. Even if there is an error, and even as some of you are saying judges are human beings, some things have happened. Review petition and curative petitions are now there. Okay, I know we've not studied it, but you all have heard about it. You can review it. Curative petitions can be there. To move away from the judiciary branch and to come over to the executive branch, at some level, you are not giving finality. This is like saying, could it be then correct to say that Parliament has the power to make laws? Yet, because Parliament laws could be bad, therefore judiciary comes in as a check and balance and does. So, in your opinion, thus, you are saying that the checks and balances, it is in fact a part of separation of powers and not an exception to it. Is that your final argument?
Yes, ma'am.
Huh? Okay. Now, see, just look at my question and the process of our reasoning. I asked you, is it an exception to, then you said checks and balance, and now you're saying it's not an exception, it's in fact an integral part of separation of powers by having the mercy power. Okay. Do many others, anybody agree with this, or do you disagree with this formulation?
Ma'am, I disagree with this.
Yeah, Chitra, why?
Ma'am, I think President and Governor, they are not judicial officers having expertise in applying judicial mind into the facts of the case.
No, Chitra, you're missing the point. Das says that this is a feature of separation of powers, and separation of powers means checks and balances. It means that when judiciary has the right to strike down a legislation by Parliament, they're not acting as legislators, but they're acting as a check on the legislators. Similarly, he says, as a feature of checks and balances of separation of powers, executive is acting like a check on the judiciary. That's really his saying.
No, ma'am.
No, that's why.
Ma'am, it's not like a checks or counter alteration or confrontation to judiciary. That final pronouncement of the Supreme Court, it's a final in that process. But it's another like tool available with one of the organ of the this machinery, like which is more of like larger public benefit rather than going into the technicality of the right and wrong. So it's more like it's like
so then it has nothing to do with separation of powers at all.
Ma'am, judiciary can decide the punishment, but execution of the punishment lies in the hand of the union. So they are exercising that authority, I think.
Okay, Chitra, what do you say? So you're not actually why I'm pushing you is that sometimes, our thoughts get clearer when you push it, like under which framework are you looking at it? And now it becomes clear to me that you are placing the pardoning power not within the framework of checks and balances, but perhaps just as an aspect of executive to implement the judiciary decisions. Okay, maybe. I'm not saying finally. Yeah, Chitra, tell me.
Ma'am, actually, this was my question, that what is the need of pardoning power of president or governor? Because if ultimately president or governor has to, if they remit or pardon anyone's sentence, then what is the use of trying the case for so many years in court and wasting public money, wasting precious time of judges?
Okay, I also have another article that I would like you to look at. Okay. Yeah, did anybody else want to say anything?
Ma'am, am I audible?
Yes, Antika.
Yes, ma'am. What I was thinking was that we cannot straitjacket this pardoning power into one block, say it's a check and balance or a separation of power or a matter of benevolence. I think it's a mixture of all three. So it's like when it falls on the mercy jurisdiction, so it's more like based on benevolence and the pardon believing into a person that he can change. And then it's also separation of powers when, say, judicial power is at one hand and executive is on the other. So this is an executive power. It's in no way altering the judicial decision, but it's curtailing it in the way of execution.
I want to make 2 points. One, Shaurya, this is not Savigny's whole spirit of the people, because it's not as if we're taking a public referendum, isko फांसी पे लगाना है कि नहीं. We're not asking like that. So I don't think it's Savigny at all. I want you all to look at Article 144. Article 144 reads, those of you who don't have it ready, civil and judicial authorities to act in the aid of Supreme Court. All authorities, civil and judicial in the territory of India shall act in aid of the Supreme Court. So when the Supreme Court says this person must be hung, then you are expected to comply with the order of the Supreme Court. Okay? Otherwise, you are guilty of civil contempt. Not criminal contempt, civil contempt. Now, here President is exercising. Now, in the Maru Ram case, which is an important judgment where where Supreme Court was interpreting the power of pardon of the governor, Maru Ram. Supreme Court explained this as a constitutional power. So, because some of the people at the bar were arguing that this is a sovereign power. The sovereign power which was above even the judiciary. And in India, we don't have any power like that. So the court says it is a constituent power. Its origin is in the old mercy petitions that the king could receive, where there was a miscarriage of justice. But right now, this power is being exercised. We don't even call it as a mercy, as a pardoning power, which is necessary in order for examining those aspects which may or may not have been examined by the courts. Remember that the judiciary is bound by the rules of evidence. And the rules of evidence only allow relevant and admissible facts in front of it. So if a question arises, did this woman commit murder or not? Then the only thing the court will look at is this piece of evidence admissible? Is this piece of evidence relevant? The fact that after committing the murder, she is currently now become pregnant and is carrying a child is an irrelevant fact from the point of view of the evidence. The fact that she has given birth to 3 small children may be an irrelevant fact which the court is not permitted to take into account, because we can only examine the regeste, the transactions that happened around the event which you are trying to prove or disprove. Relevancy and admissibility is confining it to that. And then you come to a decision, Hanji, this woman did commit the murder. And it was a rarest of rare case. It was done in cold blood. It was very bad. Therefore, we are going to imprison her for life. Now, this power has to be given to the executive, because this pardoning power allows the president to say that we don't want to hang a woman who is carrying a child in her womb, because unknowingly then the state will be killing 2 human beings instead of just 1. So you may decide to postpone the sentence. When you postpone the sentence, you are giving a respite. A respite. Or you may say that she has to undergo an operation. and she is undergoing life sentence. But for 2 years, she needs to get treatment for this operation. Then in which case, you can give what is known as remission. Look at this different word, remission. A temporary suspension of the punishment fixed by law. It's a remission. Or you can do pardon. What does pardon do? Pardon wipes out the guilt completely from the record of the human being. So if presidential pardon is given, notwithstanding a valid court of law holding you to be culpable and therefore an accused and therefore convicted, the act of pardon erases the entire judicial record. In remission and respite, oh my God, it's 1:35. I'm sorry, and you all have classes, right? We will discuss tomorrow. Tomorrow is also our tutorial hour. So my last 15 minutes will be any questions from anything that we've done so far, but I will continue. Epuru Sudhakar. So 2 students had prepared Epuru Sudhakar. Who are they? Who had done?
Ma'am, Das, Sudhir and me.
Okay.
Ma'am, I also have prepared. You have assigned this to 4 students.
4 students, right? Kehar Singh, Epuru, and one more. So please come prepared so that you can make presentation on the facts of the case. Okay?
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।